Welcome everybody to Spin Legal on Wednesday, June 12th, 2024. And today our topic is lying to your legal representative, how it can impact you, and what it can mean for your case, if you even have a case anymore. Okay, so just before we get started on this, let's remind you that you can contact Invictus Legal LLP on 905-688-5598, or you can email Angela at weareinvictus.legal, or me at peter@weareinvictus.legal. And you can contact our website at https://weareinvictus.legal. All right.
Yep.
So I will hide that. I will copy that,
because it does have that comma before the dot before legal. You got to take the comma out. So
no,
it's weareinvictus.legal.
Ha! There you go. There you go. Edit there. There was a comma there in that. Thank you very much, Angela. I didn't see that. And that means there wasn't a website put into last week's episode, but here I am going to post it so that our people on Facebook and on YouTube can access the website. And here we've already got a Robert on YouTube. All right.
And he just sits right at his computer waiting for us to start. I love that.
I love that as well.
Yeah.
So let's get started. So lying to your legal representative, there are consequences, and it's time that it's people that are coming to legal representatives that need to understand those consequences. So let's talk a little bit about that, if we may, Angela.
Well, there is a lot of consequences. For example, don't think your legal representative won't find out, because somebody else will find out for them and deliver the information, sometimes at the most inopportune time.
So here's the thing.
Just before you go into court or a time of disclosure.
Here's the thing. So you come for a speeding ticket and you tell your legal rep, oh, I've never done speeding before. A legal rep comes to the court and asks the prosecutor for the your priors, etc. You know, the what they have against you. And
you find out that they've been the candidate for the world's worst driver. Okay?
And what the prosecutor brings is this lot, right?
Mm-hmm.
Right.
Yep.
So
and he'd never had a speeding ticket before.
Never had a speeding ticket before. Yeah.
Oh yeah, sure. Maybe he's got suspensions, careless, everything else, dangerous, driving while disqualified. Yes, I think so.
And that's the problem, isn't it? Yep. We had one of our paralegals in traffic court.
Yeah,
we had one of our paralegals in traffic court.
This is the first time I ever got caught. Yeah. And they got the thing there. Find out that she's been to this rodeo before.
Yeah, absolutely.
And the thing is, that changes how your legal representative represents you, and you usually have less options if you're planning to plea bargain it.
Yeah.
And the sentence that you get might be more serious.
Yeah. And the consequences are not just, okay, the obvious thing about criminal court is, oh, well, if I lie, the judge is going to find me guilty. Yeah, probably. But the consequences are way wider than that. And we'll go into these in turn. Because if you're going into, so you tell the landlord and tenant board, I paid my rent, Your Honor. Well, it's not Your Honor there; it's Madam Chair or whatever,
or Mr. Chair.
Yep. Yeah. And it turns out the landlord produces evidence to show that you hadn't paid your rent. Hey, you're out of here. That's the consequence, isn't it?
Mhm.
You know, one potential consequence of that.
Yeah. Or they
So
have text messages from you. Oh, can you set my rent on Friday? But then, of course, Friday comes and goes. There's no rent. Then there's another text message, the same thing. Oh, I'm sorry, I couldn't pay it on Friday. Yeah,
yeah,
and you always paid your rent on time? Yeah. Right.
yeah. Oh yeah, and that whole text message gets put up to wherever. So the whole consequence of lying as a problem, potentially has a problem, right? So what do you need to so what do you need so why do you need legal representation? It's likely because you have a legal problem to solve.
Yeah,
So
but you don't want to lie either because then you have two legal problems. So
yeah. So in fact, actually,
one's called perjury.
you're coming to my office with a big bundle of work, and you're saying, "Hey, Angela, can you help me with this? I've got a problem. Can you help me?" Right?
Hmm.
Um, and that's essentially what happens to start the process. So, um, and to be quite honest, we've had some people through the door that when they've come into our office in the first instance, I've kind of said, we've ended up with the end of the case, end of hearing them, and we said, yep, we're not going to take these people on as clients because they're lying through their teeth.
Hmm. Especially when they're even if they're telling you or narrating their story or narrating their case to you, and then they're saying one thing early on in the conversation, and then in the middle of the thing, they say something completely different about
Yeah,
the same set of facts,
yeah,
right? And then you kind of say, "What?" I said, "I just need you to move back a little bit." Like you said that you were at the place on June 15th of last year. I said, but then later on, you say that you were never there.
yeah,
So, I mean, which one was it?
yeah,
And why are you telling me two different stories?
yeah.
Right?
And that story matters because let's be honest about it. We rely, we as paralegals and lawyers the same, rely upon the information provided by you, the client, in order to get you the results you need. So you know it starts with that consultation right at the very beginning. We've talked about consultations in the past.
Hmm.
It starts there and goes on from there through to representation in the court. And at the end of the day, we rely upon the evidence that you give. And there's a certain thing called evidence that we need to actually build your case. And,
Hmm.
okay, so you tell me that you earned $150,000 for the last 5 years, but you can't produce your employment. You can't produce your employment record
Or your tax returns or
or your
anything
tax
that would
returns, or
answer to that.
yeah, yeah, or exactly that type of thing. And now that might only be a small part of your case, but it makes other things in your case less believable.
Yeah, exactly. And this is why when we go in there and try to do this, we need as much evidence to build your case.
Yeah,
And yes, like sometimes we've heard from clients, but I don't think this is relevant, but I've got here, but it's not relevant. I said, let us decide what's relevant. If you think that something is not relevant, that doesn't necessarily mean it's not relevant to your case. We need all the information. If you think that your case, oh, well, this is going to ruin my case if I tell my paralegal, tell us about it. Let us fit it where it fits within the case. Let us build the narrative. The problem that many people have, they think that if they tell their lawyer or their paralegal that what weakness or something that could be used against them in the case, if they tell the truth about it, they think that automatically that the case is destroyed. Not
yeah.
necessarily. We
Well, in
just
fact,
work on a narrative with you. What do
yeah,
you want us to tell the court?
yeah.
What do you want us to tell about things? That's how we go about things.
And in fact, actually, one of the things I learned in bar school is that, hey, for example, um, essentially, yes, you've killed two people before. You've committed murder before, but I didn't do this one. I swear I didn't do it. Well, you don't manage to do that by saying, oh, but I didn't kill it. I've never killed anybody in my life, right? You kind of got to admit to the earlier killings. In fact, actually, that makes you more believable in a way. That's what we were taught at bar school. So your client is saying to the court, yes, I killed Joe Smith. He was a fat, ugly bastard. He deserved it. He deserved everything that was coming to him. Yes, I killed Mary Jones. She was a whatever. She deserved everything that was coming to her. But Joseph Marino, no, I did not kill Joseph Marino. Not now, not ever, not in a million years, because he was a nice guy and never deserved that. I was at Joseph's funeral and I cried for a week, type of thing. Right, that is much more believable. Yes, you've got a flaw in your story,
because this is the story that when Paul Bernardo was on trial for his killings of two, Leslie Behaffey and Christian French, when he was on trial for that, he was saying, yes, I raped a lot of women. I was known as a Scarborough rapist, but I never killed anybody. So that was the narrative he worked with through his lawyer. His lawyer may have known that he was involved in the killing, but this was the narrative that was presented to the court. But when you start lying about it, saying, I never killed anybody, that all that's going to do is ruin your case. Because somebody's going to go out there and they're going to find your DNA all over the place on some kind of weapon or whatever. And they're going to say, yeah, then how did your DNA get here? How did your blood get here? Your fingerprint? So these are things that you have to work, because once that information is together, then it makes it a lot easier for your legal representative to bring the narrative that fits you the most and brings you in the best light before the court. And
the interesting thing about that is that I know we're talking a murder case and we don't deal with that kind of thing, but it is interesting about how that whole thing goes. And that's where, in criminal, you're often telling the most about whether a person's lying or not. And criminal judges are often those that are most attuned to the potential that people are lying.
Yep, exactly.
Right? And
I remember one time I've been to court one time, and a judge says, people always lie. He said that. Hey, and I just sensed that you're lying. He said this to one of the witnesses or something. And somebody said, well, why would I lie about this? There were self-reps. Right? The guy said, well, why would I lie about it? He says, well, and he did outline it, because you said one thing at the beginning and you're talking about it. And then later on, you started talking about something that could not be possible if the first statement was true.
Yeah. Right? The power was out on the 14th of July, but on the 14th of July, I erased the data from the computer.
Yep. And then we had this whole big power outage in a whole Eastern Seaboard. And that's when all that happened. Remember 2003, guys?
Yeah.
It happened here.
Okay. So essentially, lawyers and paralegals build your case around the information you provide to them when asked to provide it. And obviously, you come in for a consultation. That consultation, you're asked to bring documentation, and I get it that you don't have every piece of documentation about your case on the day you walk into our office. And when
you come into our office, you'll have a better idea about what kind of documentation you might need to seek.
Yeah. And
Okay?
well,
Many
he's saying
people
to you,
didn't think, well, I've got had some text messages here and there. They may not have understood that that is just as relevant.
yeah,
Text
oh,
messages.
absolutely.
Or
In
I got
fact,
an email
text
last year that said
messages are some
this,
of the in fact, text messages are some of the best evidence there are on the planet. And when you consider there's probably, there's probably 10 billion text messages sent per day.
Yeah, I hung somebody on a text message one time. Okay?
Yeah.
But I say, well, if you're saying that this didn't happen, how come you sent this text message on Sunday? What
Yeah,
did this mean?
on the 14th of July, you said you never met the plaintiff. Well, how come you on the 15th of July you said thank you for our meeting yesterday?
Yeah, isn't that amazing?
Yeah,
And
yeah,
this is the kind of thing you need to tell us about. Okay? Don't tell us that you've never met them. You tell them that, yes, I knew these people. And yes,
well,
if there's a damning text messages, give it to us.
and
Because guess
again,
what? The other side's going to take those text messages and they will use it against you.
yeah, and here's the thing: no case is perfect. Your case will have flaws in it. The same for the other side, right? And and hey, my approach to a case with flaws in it is that I approach it head on. So,
Mhm.
you know, so you
We
know,
let you talk about it. Like, for
yeah,
example, if
exactly.
there was some kind of issue or deficiency in your evidence, we bring that to the court first in your direct examination. Okay? That way, they can't go back under cross examination and then try to murder you that way.
Yeah, yeah. Because the point being is that if it's not brought up first, I wasn't there. I wasn't there on the let's talk about the 14th of July. Yes, I wasn't there, Your Honor. I don't know what happened on the 14th of July. And then the defense slaps down on the table. Here's the evidence. Now, on the 14th of July, if you turn to page 53, it says at the top the date 14th of July, and it says Mary Jones was present. It's got her. It's got you. It's got you signed into the guest book on the
Mhm.
14th of July. So
Is this your
sure
signature?
you were.
They will ask.
Yes,
Okay? So
they.
this is where you have to be very careful.
Yeah,
Because if you're not honest here, I can present the narrative. We can present the narrative, and we bring that forward to the court first if there is a flaw like that.
yeah,
And you can explain it. You can
exactly.
explain the flaw. You'll be allowed to explain it in the court. And that way, it kind of lets your case down a bit so it doesn't look so bad to the other side, and they're not going to bring it up again.
Yeah, so you were there on the 14th. You were. Yes, I was there on the 14th. Um, but I left at 11:43. In fact, actually, if you see me, the police officer at 12:47 on the 406 caught me speeding doing 142 in a 100 zone. Nearly took my car away. Right. So that evidence can therefore show that you weren't there when Mary
Yeah, because
Jones.
you're busy dealing with a police officer in another case.
Exactly, and that's the one time you actually want to pay your speeding ticket, isn't it?
Yep, exactly. And I have it date stamped.
Yes. Can I have it date stamped, Your
Yeah,
officer?
yeah. Just
um,
to just to
so
prove that I didn't hide the body. Oh, oops.
yeah. And the point being is that the point being is that no case is perfect. Absolutely no case is perfect. There are flaws in all of them. Now, largely those flaws are probably immaterial, and even if your paralegal or lawyer is probably not going to raise anything to do with the flaws and doesn't really need to protect against those flaws because they're minor and insignificant, but sometimes they're big because you were at the scene of the murder when it happened,
Yep.
near the time it happened.
They all want to know, where were you on July 14th, 2023?
Rob thinks I'm a speed demon. Yeah.
Yep, he is.
No, I've never been over the speed limit, not even 101 kilometers an hour. I'll have you.
Yeah, sure.
That's the official story.
Yeah, it's usually where you travel with the speed of traffic. And that could be 105, 110.
Okay. So so that's actually where we are really, so every case has got some flaws in it. But I think there's some issues that if we know about the flaws and we're representing you, there's likely to be less of a problem than if the other side brings it up, because the other side's going to drop a massive document on the desk and the whole courtroom's going to shake, and now the drama starts, right?
Yes.
And now for all of the truth, every single truth that you have told in the courtroom, and there are 1,026 items of truth that you told, and it is all brought to shatters because of one lie that you told.
Yep.
I wasn't there on the 14th of July.
And if they can prove it, then the judge will say, how many other lies are they telling?
Yes. And that's the whole point about this, is that how you one lie, and that could be your case gone.
Yep.
Right? So if you lie, it can definitely affect your case. That's for sure.
Definitely.
And okay, we were talking in jest about a murder case, but it doesn't matter what kind of case you've got, whether it's murder, or
you have contract breach or dispute.
Yeah.
There's a lot of different things that could be done. Like, for example, there was some significant cases. Like, sometimes I would have to remind the other side when I know they're starting to lie and I'm interviewing cross-examination. You must remember that you are under oath. Okay. And I just want to ask you to repeat. And is that your testimony?
Okay. Well, I love the is that your testimony?
Yeah.
Can you?
I did that at a case recently. It was an all-day hearing, and it was just incredible the stuff that came out of the other side's mouth.
Well, I heard this one, and it was like, okay, so you told us that this happened. No, I didn't. I said that happened. So then you go on a couple more questions. So I remind you that you told us that this happened. No, it didn't. I told you that happened. So if that happened or this happened, you must be lying then.
Mm-hmm.
I can't believe either one of these, can I?
Yeah, and sometimes I've had to ask under cross-examination. I don't accuse them of lying directly. The best way to do this is in testimony earlier today, when you were asked this, you've made a statement this paraphrased as, and now I'm asking you a question which relates to the same thing, and now you're making a statement of this. I just was wondering if you were being factual then, or are you being factual now? Because I seem to be hearing two different stories or two different versions of facts.
Yeah.
If you can tell me which one, it can satisfy the court.
Okay. And one important factor to note in all of this is that lawyers and paralegals are sworn officers of the court and are and cannot lie on your behalf.
Yeah. If, for example, if you know something about the case and it's been given to you and you understand that this came from your client, you cannot try to deny to the court in any of your presentations or questions about that issue. You cannot, or even if a client tells you, oh, don't tell them that you got this from me. Can't say that.
Hmm.
Okay? We have to go through what we try to do is we try to build a narrative that looks most favorably on our client, and we try to move that advocacy to the largest extent. And we can't always protect you. We cannot protect you by lying. We can only protect you by trying to work things around and getting the least and getting the most damning stuff through us as opposed to the other side. And we work through the other side the best we can to come up with something that would be presentable for the court. Don't try to tell us to lie for you, because we won't, nor will we try to make things up because we can't come up with a reasonable explanation. These things have to be there and presented. If you're like, this is why I say, when you're under cross-examination, I said you need to be truthful, okay, but give short answers, okay, yes, no, and if you don't remember, you don't remember. Don't try to go into all kinds of, oh, it might have been this or it might have been that. No, I don't remember. Okay, these are things that why you have to be very, very careful when you're in it, because any type of language or any kind of phrase that's being used can be used, and the judge may come into a situation where it looks like your credibility is shot, and many cases are decided solely on credibility.
Well, and that whole point about credibility, that credibility matters, because at the end of the day, you know, as I just said a few minutes ago, you could have told 1,000 truths, right? But it all turns upon that one lie.
Mm-hmm.
That one lie that you made makes the judge now say, well, truth number one, here's $1,000 off his case. I was about to award Mr. Smith $1,000 for number one. I was about to award him $500 for number two. I was about to award him $3,000 for number three, etc., etc., etc. Right now, well, I can't award Mr. Smith anything. You're a liar, sir.
Throws it right out the window. The credibility's gone.
The credibility's gone. Yeah. And it's all about credibility.
And you can tell us anything. Don't be embarrassed. You can tell your legal representative anything.
Because we can't tell anybody.
It's not that we cannot be offended. It's just that whatever you tell us is privileged.
Yeah.
Protected. We can't be brought up into a court and put on the stand and said, hey, what did Joe Smith tell you when he went to see you at the office on November 3rd? No, you can't. Okay?
Yeah.
But let us determine what's relevant, how to present and move forward on your narrative.
Okay. And moving on, you know, please note your legal representative can fire you if you're caught lying.
Absolutely.
And there's a great one that I learned in bar school. Yeah, there's a great one that I learned in bar school, which was that suddenly you become middle of the trial, you suddenly become aware of something, and you turn around to the court in a private session. You turn around to the judge and say, Your Honor, I find myself this morning professionally embarrassed and must recuse myself from the case.
I had to do that in the middle of a case of my own. Hey, this person was saying a number of things at a tribunal hearing, and it was a multi-day hearing. And at the end of the second day, I had enough. And I said, because this was said, because of this. And I said, you can't do that. I have lost the confidence in your ability to properly instruct me and to properly inform me, and also to properly participate in your own proceedings. Yeah. And of course, as soon as I did that, the person was very upset. They tried to continue to do this stuff on their own, and it was the adjudicator, it was the opposite side, there was other people. They all wrote me, and even in their decision, they wrote me and they understood why I did this, because they saw it happening. And they were probably wondering when I would drop the client as opposed to if.
Robert says that must be an awful feeling.
Oh, yes, it was. I didn't like to do that. It's not something I like to do, but I had no choice because to continue to support this client when there was one thing said and another thing said or done, it does not match up and it puts me in a conflict. Because I have duties to the tribunal, just as much as I have duties to the client. And I can't be going to a tribunal and support this kind of stuff.
Yeah. Okay, so here's another one we hear particularly early on in a case. Something like, I didn't tell you that because it didn't seem relevant. Essentially, what you need to do is let us know, right? There are, yes, absolutely true that in every single case that it is, every single case that anybody ever takes, there are many things that are relevant and many things that are irrelevant. And here's where I've got to tell you a story. First ever case I did when I was sat at the LTB, and I'm thinking to myself, well, what evidence is relevant to this case? And what I made the mistake of was my client had sent me a whole heap of stuff, some of which I hadn't really thought about, but I was in an outright panic about what files I'm putting up to the board, and I stuck every piece of evidence that she showed at me up onto the portal. And then I realized, well, I was like, I realized when the hearing happened, I'm like, well, I gave them some information that I should not have given.
Mm-hmm.
Sweating. I'm like, it's hopefully nobody notices this.
Mm-hmm.
But actually, nobody did notice it. I put up some. Yeah, you did. I did. But
that's why I sat beside you, just calm down.
Yeah,
that you can't do anything about it. Let's work around it.
Yeah, exactly. And the whole point was that when you start in the game, you think you know what's relevant and what's not, and sometimes you need instruction about what's relevant and what's not. Once you've been doing hundreds of cases, then drawing the evidence up, and I've had sometimes somebody say to me after the end of a case, but you never showed the picture of whatever. Yeah, because if I'd have showed that picture, I get the point that what you were showing, there was 68 degrees. But the problem is the background of the picture was that it was out in the forest somewhere.
Yeah.
So the thermometer at 68 degrees, it's not believable that your kitchen was at 68 degrees when I've got a picture of it being in the forest.
Yeah, exactly. Yeah, or that if I put this picture up, it would also put you in a situation where it could also hurt your case.
Yeah, that's another one. Yeah. This information could be seen two ways. Yeah. Right?
So that's why you try to minimize that type of thing where there's a question about it. Okay. But you do put up stuff that are supportive. Emails, text messages that support your case. Sometimes I put the whole lot up and then I just highlight specific sections. So to kind of draw people's attention away from where it might be a problem, but I might ask you something where I might hit upon it.
Yeah. All right. And the important aspect to learn about this is that for the person who's deciding your case, it's a trust issue. And if you want to lose your case, then keep on lying.
Yeah. Like I'm sure people who want to go to court or to tribunals or whatever, hey, this is one of the things you don't want to do. You don't want to keep going there and losing all the time. Okay, because it doesn't make it very good. Like then you'll become like the Toronto Maple Leafs. Okay, and why they never seem to get any Stanley Cups.
They can never get through the first round of the playoffs, but at least right now they are in the playoffs, or at least they were. This year they were in the playoffs. Last year they were in the playoffs. So in fact, you've got to be there a couple of years at the first round of the playoffs in order to get to the second round.
Yep. But I think we still got the Oilers.
Yeah, they're 2-0 down right now, so I don't hold out much hope for them.
Yeah. Anyway, that's just one of the things that's very important.
So, the point being is that when you're taking your case to court, and only when you've got a hearing going on or you've got the trial of two pieces of evidence, at that point you've got the situation whereby you have to convince somebody that your version of the truth is the truth.
Have you ever gone to court where there is not a stick of evidence on either side? And it was just her testimony and his testimony?
Once it didn't feel right. It felt odd.
Yeah, I just don't understand how these cases even get to that stage.
Yeah, you're right. And at the end of the day, and actually the worst one that I've had is actually, and this becomes a problem in our particular age. How many cases there was a case? Well, I'm looking at a case that relates to evidence and information that happened in 2016, 2017. Because I'm consulting on that particular case. Well, how can you potentially even remember what happened in 2016, 2017? I had another case where a person gave evidence in a 2018 case that was just shut down just before COVID. And I asked the question, so when did you have the car inspected by an expert? And they answered the question, yeah, on the 12th of July. The trouble is, it wasn't the 12th of July. It was the 15th of June. It was the 12th of July was the date they bought the car, and that was fatal for their case.
Yeah, you got to really watch this.
Yeah.
Okay? It's very important. Okay? Like I have one coming up on human rights. I don't have a date set. Somebody has alleged somebody did something. There's no evidence. There's no other text messages, witnesses, anything. Okay? It's not that my client has anything either, but neither of them have witnesses or any evidence. So it's like, I don't even know how it got that far.
Yeah.
These things really, I think there needs to be a bit better screening of these things.
Yeah, that's interesting because, when we're in the business of evidence.
Yeah, evidence is, and this is where we work on things. Like for example, if someone's going to accuse you of doing something wrong, like if they're accusing you of stealing or assaulting somebody or whatever, you want to have things based on evidence. You want to have a case where they have to prove beyond a reasonable doubt that you are guilty of this. Okay? Not just somebody's word against yours.
Yep. And it's, hey, hey, Angela stole the biscuits. No, she didn't. There were no biscuits found anywhere around where Angela was. No. Fact is that Angela ate them all.
Yeah, disposed of. Yeah. Well, Peter has a stash.
Anyway. So so all joking aside, so that's an important aspect about why you, why you need to be telling the truth. And there's another aspect here. Robert's saying some people go on emotion.
Absolutely. There's a reason why people file these cases. Because they're angry at the other person, angry at someone. But emotion, anger, sadness does not create a legal case. Not in itself.
Yeah.
It may, but it doesn't necessarily create a legal case.
Well, at the end of the day,
my boyfriend broke up with me, so therefore I'm angry because, he owes me money for all of this stuff because I took him out to dinner more and I spent more money on going to the movies than he did. Okay. You don't sue over things like that.
Yeah, he owes me $1 million because I spent $100 on a date with him.
Yeah, exactly.
Oh,
Like,
and by the way, we also had sex. Well, he should pay for the sex.
oh,
Like the court's going to accept that one, eh? Yeah. Okay. So, all joking aside, if you need to contact Invictus Legal, you can do so at 905-688-5598 or email Angelo at weareinvictus.legal or me at peter@weareinvictus.legal. And the website is https://weareinvictus.legal. All right.
yeah, that's going to be corrected.
.legal, not okay.
Not,
So let us
not comma dot legal, just
not comma .legal. That was there you go. There you go. This is now correct. Okay.
Okay, good.
Yeah.
Yeah, I almost caught him in another lie.
Whoa, that was not a lie. That was just that was a typo.
Lying about a website.
Yeah. Well, Robert says thank you, and we thank you as always for coming here, Robert.
Absolutely.
Wouldn't you? You wouldn't get far with Judge Judy. Yeah, that's true.
Yeah, she's the one who says, "I think you are lying."
Oh, she calls him out. She calls him out. Not that I
Yeah.
watch her anymore. I've given up watching Judge Judy.
Oh, she could
here
be
you go.
funny.
Here you go. Here is your final statement.
Okay. So what you hear on Spin Legal, like what you've heard today or what you've heard on any of our other earlier shows, this is not legal advice. If you need legal advice, then please contact a paralegal or a lawyer, and then they can advise you to your specific situation.
And that doesn't, we would appreciate your call always, but it doesn't have to be us. And some of the topics we bring up are just, topics of interest to people who asking questions about the law. And next week, we shall be looking at the duties of a client and the legal representative.
Oh, that's going to be interesting.
Right. So that's what we put down as we plan for next week. And the week after, we're planning to do questions to ask your lawyer about costs.
Yep.
The cost of your case.
Yep.
Okay. So we've got those couple of questions to discuss and look forward to in the near future. So thank you, everybody, and have a great day. And I guess that we will be saying goodbye here.
Okay.